Hi, my name is Schyler Church. I am a California real estate broker as well as a member of the education department at Accredited Real Estate Schools. We offer the course requirements to be eligible to take that state exam in California, but also varying levels of prep to make sure you're prepared to pass that state exam. And if you are preparing for that state exam, what type of vocabulary do you need to know for that state test? And today we're going to talk about 25 more terms that you should know about and should know them very well for state exam purposes, but also for when you're practicing once licensed. So hopefully a lot of this will be review, but if not, this should be a good study tool to make sure you're on the same page of knowing the material that you need to know for state exam purposes. Now, this is only 25 questions. We do have previous vocab videos with other terms, so make sure to check out those as well as other exam prep options that we offer. If you like these videos, though, make sure to give us a big thumbs up and subscribe to our YouTube channel, as well as giving us a comment. We love hearing from you. And if you do like our program and are interested in other courses or exam prep, I have the link below going over the options that we offer, because of course we would love your business, but hopefully you are liking our YouTube channel. So let's get to it and start with our first term that we have. Documentary transfer tax. Documentary transfer tax. This is a tax that the state has allowed each county to collect on a real estate transaction when there's new money. So new money refers to any type of money except a loan assumption. So what this says is a state enabling act allows a county to adopt a documentary transfer tax to apply on all transfers of real property located in the county. So it would be paid 55 cents per $500 of new money in a transaction. Or you could look at it as $1.10 per $1,000 of new money in the transaction. New money is any type of money except a loan assumption. That would then be considered old money or existing money. But a new trust deed, cash, that's all new money in the transaction and would be subject to this documentary transfer tax that the county is able to collect in the location where the property is located. So documentary transfer tax. And the seller usually ends up paying this, usually. Then we have zoning. So when you think of zoning, you should think of police power. Police power, it goes hand in hand. So act of city or county authorities specifying type of use to which property may be put in specific areas. So the zoning is used to implement the county's general or master plan. And they're able to do so with police power. So it goes hand in hand. A sheet. What is a sheet? Well, when you think of a sheet, you should be thinking if somebody dies with no will, but they also do not have any heirs. So what happens is it would then escheat to the state of California. So the reverting of property to the state when there are no heirs and no will. So there are no heirs to collect the property, and there's no will to specify where the testator is wanting their property to go. So it would escheat to the state of California. And remember, there is that 5-year period. Then we have interim loan. Interim loan. So an interim loan, when you think of that, an interim one is one that is in progress, basically. It's currently being used until another loan happens. So what it says is a short-term temporary loan used until permanent financing is available. So a construction loan is usually what is referred to as an interim loan for state exam purposes. Short-term, temporary, until you can get a permanent loan. Interim is the one in the interim. Eminent domain. Eminent domain. So remember, this is one of the sovereign powers of the state. What does that mean? I'm going to give you a moment to think about it. Sovereign power of the state. Well, this power allows the government to take private property for public use, but they have to justly compensate the property owner. So exact definition is the right of the government to acquire property for necessary public or quasi-public use by condition. However, the owner must be fairly compensated. So eminent domain, it's a sovereign power of the state where they can take private property for public use as long as there is fair compensation. And that is eminent domain. And this is under the condemnation action. We're not talking about condemnation for like a health and safety issues, but the actual action. Moving on, we've already done 5 terms. See, going pretty fast here. So now we have sublease. Sublease, well, it has the word lease in it, but we're talking about sublease. So sublease is when you're able to, as the lessee, so a current tenant, and you then actually sublease. So you take your lease and lease it out to another person. So that is called a sublease. So you become a sublessor, and then the person who is now having possession of the property is the sublessee. So a lease given by a lessee. Now, sometimes a lot of property owners do not allow subleasing, but you need to know what a sublease is. So, and it's also referred to as a sandwich lease because the lessee, the tenant, is still they are not relieved of their obligations of the lease. They have now just gotten a new sublease with a sublessee to then assist with it. So a lease given by a lessee. An easement. So this is a type of encumbrance that limits title based on use. What type of easements, though, do we have? There's quite a bit. Well, the first exact definition says it's a right, privilege, or interest limited to a specific purpose which one party has in the land of another. So when we think of easement, we could think of a pertinent easement, a prescriptive easement, an easement in gross. There's a lot of different types of easements that we have out there. But it allows someone for limited purpose for being able to use the property. So remember, within a pertinent easement, that runs with the land, and there's that dominant and tenement servient, dominant tenement and servient tenement. And the dominant tenement is the one that has the appurtenant easement and has the ability to basically use the servient tenement property for a specific use. And when the dominant tenement sells the property, it goes with the land. The only person that can actually basically terminate an easement is the dominant tenement, because the servient tenement is the one that is burdened over it. Okay, so an easement. The Holden Act. Holden, so the Housing Financial Discrimination Act of 1977. So you should be thinking of fair housing. This is a state fair housing law in California. And this is one that prohibits discrimination in lending. So this really comes into account of redlining. So it's designed primarily to eliminate discrimination in the lending practices based upon the character of the neighborhood in which real property is located. So a lot of times what they're talking about here is redlining, where sometimes lenders, they used to take a big red pen on a map and circle an area, and they said, within this red line where this circle we made, we will not make loans. And that is discriminating and not allowed. So that is really what we're talking about. So Holden Act, it prohibits discrimination in lending, and you should be thinking hand in hand with redlining. Proration. So prorations happen a lot of times in escrow because, for instance, like the seller may have overpaid for an item. So for instance, let's say they got their property insurance and they paid for it. Let's say they paid the whole year up front. They sold the house in the middle of the year. Well, they're only actually needed to pay for insurance for half of the year. The other half, the buyer needed to pay or needs to pay. So the seller is going to be wanting to be reimbursed. And this could go vice versa, where if the buyer is entitled to funds, for instance, like rents, prepaid rent. So what is a proration for a specific definition? It's an adjustment of interest, taxes, and insurance, etc. on a pro rata basis as of the closing or agreed upon date. And an example is fire insurance. Fire insurance is normally paid for 3 years in advance. So, for example, if the property is sold 2 years later, the seller will want to receive 1/3 of the advance premium that was paid. This is usually done in escrow by the escrow holder at time of closing the transaction. So this is where the seller is able to be reimbursed for what they overpaid. But it could also be where the seller, for an investment property, received rents for a month, and they then are only entitled maybe to half of the month's rent because it closed on the 15th of the month, the buyer then will be entitled to the other half of the rent. So then the seller will be owing the buyer money. So this is a proration where it's just adjusting some type of cost or payment, something like that. So interest, taxes, insurance, really those are the most popular ones that you need to know about, as well as rent for state exam purposes. Holder in due course. A holder in due course. Well, you should be thinking of financing. I'm going to give you a moment to think of what the holder in due course is. You should be thinking of financing when that loan has been sold has been sold to someone else. Hopefully it's ringing a bell. Well, one who has taken a note, check, or bill of exchange in due course. So this is somebody that is now, that wasn't the original person that had the note, check, or bill of exchange. They had taken over it, and they've done so before it was overdue. Also, they did so when it was in good faith and for value, and without knowledge that it has been previously dishonored, and without notice of any defect at the time it was negotiated to him or her. So they're expecting this to be a seasoned note that they will get, and that there's been no... there hasn't been like late payments. There hasn't been anything to where they have knowledge of a defect or a dishonor for the note. Holder in due course. Somebody that's not the original person of the note. Grant deed. A grant deed. Well, remember, you should be thinking of deeds and how we transfer property. So when we're transferring property, the most common deed used in California is a grant deed. A grant deed is one that is a limited warranty deed using the word grant or something like that assures a grantee that the grantor has not already conveyed the land to another and that the estate is free from encumbrances placed by the grantor. So a grant deed is required to say grantor grants to grantee property description, and then they sign it. Does not need to be acknowledged. And it does not need to be recorded. However, it behooves the grantee to have a grant deed recorded. And then, so that is a limited warranty deed. It's one that is really the most popular deed used in California. And it is, because of it, they have some implied warranties of saying that the grantor, so the seller, has not conveyed the property to someone else. And it's also free of encumbrances placed by the grantor. Mortgagor. So who is the mortgagor? So it's in the word where we have the mortgage. Well, when there's a mortgage, we have the mortgagor and the mortgagee. Mortgagor and mortgagee. So who do you actually obtain a mortgage from? You obtain it from the mortgagee. So the mortgagor is the one who gives a mortgage on his or her property to secure a loan or performance of an obligation. They are the borrower. So the mortgagor would go to the mortgagee for to obtain a mortgage. So the borrower. Mortgagor obtains from the mortgagee a mortgage. Keep that in mind. So remember, and then on a trust deed, which is primarily used in California, we don't usually use mortgages. The trustor is the borrower, and they obtain a loan from the beneficiary, and they give the power of sale to the trustee. So it's keeping track of your terms. Now we have dual agency. So when we're talking about single agency, it's where there is an agent representing their principal. Well, let's say though that the agent was representing the seller, but they also found a buyer. So they're now representing the buyer as well as the seller. So that is called dual agency, and the dual agency is an agency relationship in which the agent acts concurrently for both the principals and a transaction. And remember, when there's dual agency, it has to be disclosed and agreed to by the parties. But it has to also, that also means that the agent has a fiduciary duty to both of the principals in the transaction. Ground lease, a ground lease. Well, you can infer it based on its name. It's a lease of the ground. But what does that mean? That says an agreement for the use of the land only, sometimes secured by improvements placed on the land by the user. Well, you don't really need to know about that for the state exam purposes, but you need to know about a ground lease, that sometimes the ground could be owned by somebody else, and they're just leasing the ground for a long period of time, maybe 20, 30, 50 years, etc., depending on it. And they actually decide to construct on it. So that's why a lot of properties that when they are built on a parcel of property that is a ground lease, they're not worth as much because of the land. Then we have liquidated damages. So liquidated damages, this is a predetermined amount set forth if a party were to usually breach the contract or if a certain event were to occur. This is initialed in the usually in the purchase agreement by both parties for the liquidated damages clause to be in effect. But the liquidated damages is a set amount that would be paid if one party were to, for instance, breach the contract, so the other party would be paid for their damages. And so what the definition is a sum agreed upon by the parties to be full damages if a certain event occurs. Usually in California, what it is it's 3% of the purchase price, but not to exceed the earnest money deposit. Then we have a sale-leaseback. This is also called a purchase and leaseback. This is where, as for instance, usually with businesses, if they are owning the property and they sell the property to somebody else, but they want to continue staying in the property, but doing so as a tenant, so renting it. So the seller will sell the property to a buyer, but then there will be an immediate leaseback to the seller. So the seller now becomes the tenant. This is a way for them to get to stay in the same place, but get the capital out of their property, their investment. Also, another way of doing this is sometimes what they say: what is somebody where someone's estate turns from a freehold estate to a less than freehold estate? It'd be like a sale and lease back. Effective interest rate. So we're not talking about the nominal interest rate, because remember, the nominal interest rate is the rate that's specified in the note, whereas the effective interest rate is what's actually being paid by the borrower. So what they're actually paying. So the percentage of interest that is actually being paid by the borrower for the use of the money. This takes into consideration all the fees. So it's also, we call it like the annual percentage rate, APR. But the effective interest rate was actually being paid, whereas the nominal interest rate is what's stated in the note, but that doesn't mean that it's the actual rate that's being paid. Then we have a testator. So a testator is one that deals with creating a will. So if they are wanting to leave to create a will, that is what the testator is called. So one who makes a will, that is the testator. So remember, if they're leaving real property, they are devising. And then if it's personal property, it's considered a legacy. And there's a lot of terms that go in with this. So make sure to keep up with it, with devising, a legacy. If you have an executor, executree, all of those good words. Deviser, devisee. But the testator, that's the one who actually makes a will. Then we have an encroachment. So an encroachment is an encumbrance based on use. So it's limiting title based on use. This is because it says an unlawful intrusion onto another's adjacent property by improvements to real property. An example is a swimming pool built across a property line. Another example is somebody's, like an eave is hanging across the property, or a tree, for instance, is hanging over the property line. Something that is intruding on the other person's property. It's an encroachment, and that falls under encumbrance based on use. Last 5, we have impounds. Impounds. So remember, this is when the PI becomes PITI for your payment when you have a loan. So when you're paying your loan, you're paying principal and interest, but sometimes they might require you to pay taxes and insurance with your payment as well. This is usually for loans that are 80% or greater LTV. So the correct definition is a trust type account established by lenders for the accumulation of borrowers' funds to meet periodic payment of taxes, FHA mortgage insurance premiums, and or future insurance policy premiums required to protect their security. Impounds are usually collected with the note payment, commonly termed PITI payment. So what they're basically saying here is that the lender isn't necessarily comfortable that the borrower is going to pay on time the property taxes and property insurance. They will want to collect it with the loan payment. So besides the borrower just paying principal and interest, they will usually ask for 1/12 of the insurance and 1/12 of the taxes to be collected each month. That will go into a trust type account that the lender will then pay on behalf of the borrower. And that is called impounds. So the impounds is that taxes insurance that is also added on to the payment. So that's when the PI becomes PITI. Then we have economic rents. Economic rents. So this is what the rent is for a comparable space in the marketplace. So the reasonable rental expectancy if the property were available for renting at the time of its valuation. So for instance, an appraiser is looking at a property and there's tenants in there for 10 years and they really haven't increased the rent so much. Well, they'll be looking at the economic rent of what it would be rented, what the rent would be had it be rented at that point in time. And that is the economic rent. A VA loan, well, you should be thinking of a veterans loan, because remember what that is it's for the Veterans Affairs. So a veteran, if they've been honorably discharged and certain other qualifications, as long as they qualify, they will be given a loan to assist with the purchase of real property, whereas the Department of Veterans Affairs will guarantee the lender payment of the mortgage. So they're saying that, hey, we're guaranteeing that if our veteran stops paying, we will step in and pay it all and guaranteeing it. So this is a benefit for veterans. Remember, for VA loans, they're called like VA no-nos, no money down, no closing costs. There's a lot of benefits to it. So a lot of the fees can be rolled up into the loan, and you just usually have a funding fee, but there comes to certain aspects of it. So the VA loan, remember, they guarantee loans, whereas an FHA loan insures loans. There's a difference. Then we have a maturity date. We're talking about loans here and the loan maturity date. So this is when all principal and interest would be paid back. So when the loan is maturing, as they say. So the date by which a loan is to be paid in full. So for instance, on like a 30-year fully amortized loan, the maturity date would be at that 30-year mark. Then we have an earnest money deposit. So an earnest money deposit. So we talked about it briefly a little bit ago. That earnest money deposit is what a buyer will usually, when they're submitting an offer, will usually have this deposit going with it. It's called earnest money deposit to show that the buyer is serious and in earnest. That's where the term comes from. So the buyer will usually put anywhere from maybe $1,000, $5,000, $10,000, etc., depending on what the purchase price of the property is, into escrow or in wherever they direct it to. So it could be in the broker's trust account, could be in the principal's hand, it depends, but usually it's in the escrow holder's hands. And that is so to show the seller that they're serious. And also for that liquidated damages that we were talking about, the money is then already there for that predetermined amount if someone were to have breached the contract. So a down payment made by a purchaser of real property as evidence of good faith, a deposit or partial payment. And remember, when you do pay for this earnest money deposit, it does go towards the final purchase price of the property. So if you say it's a $100,000 property, you put $1,000 earnest money deposit, well, that $1,000 would go towards the $100,000, and then it would just be $99,000 left to come up for the remaining balance. So earnest money deposits, and this earnest money deposit could, in a way, sometimes be hard to get back, because if you were to breach the contract or something were to happen where the seller doesn't want to release the funds, then interpleader action would have to be filed in court. And so there's a lot that could go into it. So this is just showing in faith that they are serious, good faith and serious about purchasing the property. So that is it for this video. Thanks for watching. I hope this video was helpful in your licensing journey and your studies. If you liked it, make sure to give us a big thumbs up, as well as subscribe to our YouTube channel so we keep producing new content. But if you have any questions, or if you'd like to check us out for completing coursework to be eligible to take the state exam, or even for preparation to help you prepare for the state test, we have tons of options, and I have our website listed below. Otherwise, I'm Schyler with Accredited Real Estate Schools, and thanks for watching.